All right, Mr. Wallace, you have 15 minutes and have reserved an additional 5 minutes for rebuttal. So if you would approach the podium, you may begin.
May it please the Court, Ben Wallace and Liz Merle on behalf of Secretary James LeBlanc in this appeal. Above all else, the District Court made two key legal errors in this case, and both of them were on the qualified immunity analysis. It erred on the first prong when it, one, implicitly held that Secretary LeBlanc violated Mr. Grant's constitutional rights, and two, it erred in essentially holding that his conduct was objectively unreasonable under clearly established law in this case. This morning I plan to briefly touch on Mr. Grant's jurisdictional argument before explaining the precise errors on each of those two steps in the qualified immunity analysis. Mr. Grant argues that this court lacks appellate jurisdiction because there are fact disputes that the District Court identified, but that's just not true in this case, Your Honors. There is absolutely no dispute about what happened to Mr. Grant, about what Secretary LeBlanc knew, about when he knew it. The only dispute is, can the Secretary be individually liable? Did he violate Mr. Grant's rights? Was his conduct objectively unreasonable under clearly established law? Unless Your Honors have any specific questions about the jurisdictional arguments, I'll turn right to the merits of the appeal.
Let me ask you, where in the record is there, I should say, is there anywhere in the record where Mr. LeBlanc is directly in the circle of communication between, for instance, I think there's some correspondence or some email correspondence from the state court judge. Is he in any of that circle of communications? Is there any evidence in the record?
No, Your Honor. There's no evidence in the record, and in fact, that's what happened. He was not involved. He was not even CC'd or anything on the emails from Judge Burris to the Department of Corrections employees in this case, nor was he CC'd on the July 8th email that Mr. Grant points to say that the department knew that Mr. Grant had not violated his parole from his June 30th conviction. So there's no dispute that the Secretary was not personally involved at all in this case. In fact, he essentially had no knowledge that Mr. Grant existed until this lawsuit was filed. So the only question is, on the undisputed record, let me back up one step. The claim in this case is one for supervisory liability. So it's a really high standard for the plaintiff to overcome Mr. LeBlanc's good faith assertion of qualified immunity. He has to show that the Secretary was deliberately indifferent and that there was an obvious policy that the Secretary could have adopted to prevent this, Mr. Grant's alleged injury in this case. And I think the real disconnect is between what the plaintiff alleges is happening as a general matter and what actually happened to the plaintiff in this case. So I think that actually leads nicely into what is the first prong. Did Secretary LeBlanc violate Mr. Grant's constitutional rights? And where the district court went wrong was in two places specifically. And you can even look at the subheading in the district court's opinion, and it's whether a constitutional violation occurred. Now I realize a subheading is not dispositive in this case, but I think it reflects the error that the district court made. And the error was, it looked at the facts as a whole, and it basically was looking at, were Mr. Grant's constitutional rights violated by someone? Not the question that should have been asked in the supervisory liability case, did the Secretary violate Mr. Grant's rights? The district court essentially flipped the qualified immunity burden and placed it on the Secretary, where the law is clear in this circuit and from the Supreme Court that once the Secretary asserts it, it is the plaintiff's burden to come forward with record evidence showing the Secretary violated his constitutional rights and, on the undisputed record, considered in the light most favored to the non-movement, Mr. Grant, the Secretary's conduct was objectively unreasonable. And One other thing the district court did was it essentially conflated what it called technicalities in the DOC's procedures with state laws. I think it's worth reminding the court that what happened in this case was subordinates in the Department of Corrections essentially relied on locally elected officials to do their jobs. Their statutory duty, in fact. That didn't happen in this case. It's undisputed. Where we're left in this appeal is that the secretary is the only defendant, but it's not any less valid of a defense to say that the secretary wasn't the one who did anything wrong in this case, especially since he had...
Let me ask you about deliberate indifference. Proof of that, I want to also reference your earlier comment that the Secretary LeBlanc was unaware of Mr. Grant's existence until the time that this lawsuit was filed. Can deliberate indifference also be shown by a general indifference? Is there a way, I mean, I'm talking about the Sigma 6 study and the years when people being incarcerated beyond their precise release date occurred. Can there not be an implication of deliberate indifference when it happens so many times, and there seems to be, without getting into the specific facts of this case, there seems to be an indifference that it's being calculated properly for anybody?
I think the answer to the question, Your Honor, is no. General indifference cannot satisfy deliberate indifference in this case because it has to be, as this court stated in Porter v. Epps, citing to the Supreme Court's opinion in Connick, and then this court later stated in a case that was a little bit different in Jason v. Tanner, there has to be a very similar pattern of constitutional violations because with deliberate indifference, the question isn't, did something go wrong? Can we come here today and look at the record in the case and say, this shouldn't have happened this way? Maybe something could have been done. The question is, was the secretary on notice that there was something unconstitutional that he was doing and that he actually had the power to correct? So going to your point about the 2012 study, as we know from the record, that study showed a number of different things, but basically what it came down to was there were some problems on the department's end. It fairly showed that. But the secretary made changes to address those issues, and they got a little bit better. That's not deliberate indifference. Deliberate indifference is knowing there's a constitutional violation and then essentially doing nothing.
Well, to be clear, I'm talking about at the pleading stage when this motion was filed, or the early stages of the litigation, I guess, is to put my question in context.
Well, this review is on a motion for summary judgment, Your Honor.
Right.
So there's been lots of discovery in this case. We're well past the pleading stage, which is why the record is undisputed and there's not a fact question for jurisdictional purposes. I think, Your Honor, though, the even bigger error the district court made was on the second prong of the qualified immunity analysis.
Before we move off the first one, I want to make sure I understand your argument about state law and how it apportions responsibility for what the briefs call the pre-class packet. So my understanding of the factual background in this case is that on July 12th, the plaintiff was transferred from the sheriff's office to the Department of Corrections, and it was the sheriff's office to deliver with the prisoner the bill of information. Is that right?
That's correct.
So you keep pointing to 15566 subsection C, which says that the sheriff has the responsibility of delivering this to you. For reasons that I cannot figure out, neither side in this case talks about the second sentence of that statute that says, if said documents, which includes the bill of information, are not tendered with the prisoner, the Department of Corrections shall refuse delivery of said prisoner. That makes it really awkward to then rely on that, because you clearly didn't do that, right? You should have, or your client, I'm sorry, the Department of Corrections.
That's correct, Your Honor.
So what do we do then with 15566C?
Is the question, Your Honor, can you rely on it at all just because what actually happened in this case was that the transfer was not refused?
Yeah.
Yes, I think it's basically irrelevant as a legal matter on this claim, because the question isn't, in this case, was a violation, did someone in the Department of Corrections violate that sentence that you're referring to in subsection C of 15566? That's not the question. The question is, did the Secretary adopt a policy or fail to adopt a policy that was obviously causing constitutional violations that he had the power to fix?
Well, let me ask it this way. Does the Secretary have a policy to, if said documents are not tendered with the prisoner, the Department of Corrections shall refuse delivery of said prisoner?
You mean, is it the policy of the Secretary to follow? Yes, Your Honor, that's essentially the policy. That's in the record. And stated differently, there's nothing in the record showing that there's a systemic failure to follow that policy, which is the legal question that's at issue here.
So it was a one-off that someone looked at the pre-class packet and either didn't notice that there was a bill of information or made a mistake here, but the policy would be to look at it when the prisoner's transferred and then to make sure that all the stuff that's supposed to be in there is in there?
That is the policy, and I think the way I would say it is it's the plaintiff's burden to prove his case, and there's nothing in the record suggesting that it's not a one-off.
That it's not what?
A one-off, as Judge Oldham referred to, as in that this is the only time that the department has ever essentially failed to comply with that second section, refusing delivery of the prisoner. Turning to the second prong of the qualified immunity analysis, Your Honor, none of the cases cited by the district court or the plaintiff in his briefing are even remotely close on the facts, nor do they suggest that it is unconstitutional for a state prison administrator to rely on locally elected officials to follow state law. Stated differently, the Secretary had no fair notice from either the Supreme Court or this court that his conduct in this case was unconstitutional. I know Your Honors are familiar with the cases in the briefing. I'll just touch on them briefly. Some of them, Worrell versus Kern, for example, 1968, that case involved a sheriff and a pretrial detainee, and more importantly, the sheriff actually received proper notice that the pretrial detainee's charges had been dismissed in that case, and then essentially it was lost. Then there's Douthit versus Jones, 1980, also involving a sheriff and a pretrial detainee. Another big importance in both of those cases is they weren't supervisory liability cases. They weren't failure to adopt policy cases. There was no finding of deliberate indifference in those cases. Moving closer to the present, Your Honor, Porter versus Epps, in that case, a jury denied the Mississippi Department of Corrections commissioner's qualified immunity, and this court reversed. And it didn't hold that the commissioner had violated the Constitution. It just held no violation of clearly established law in that case. At the end of the day, Your Honors, there's also one other case, I'm sorry, I forgot to mention. This is Powell versus Barrett. This appears on page 20 and 21 of Mr. Grant's brief. And they cite it because it's from the Northern District of Georgia, and the judge in that case said, we've been unable to find any case where it's permissible for a pretrial detainee to be held for more than 48 hours after a scheduled release date. Well, it turns out in that case, 7 years later, that same judge at the summary judgment stage awarded the sheriff qualified immunity and basically said, when there's things happening outside the sheriff's control that are causing certain quote-unquote over-detentions, it's not the sheriff's fault. And the 11th Circuit affirmed, and that's at 511 Federal Appendix 957. Your Honor, there's no case from the Supreme Court or this court even remotely close on the facts. For this reason, the Secretary is entitled to qualified immunity either on the first prong or the second prong. And if Your Honors have no further questions, I'll reserve the rest of my time for rebuttal.
All right, thank you, Mr. Wallace. We'll hear from Mr. Most.
Thank you, Your Honors. Good morning. William Most on behalf of Plaintiff Appellee Rodney Grant. Last year, in Hicks v. LeBlanc, this court wrote that Secretary LeBlanc could be held liable for the failure to, quote, immediately compute an inmate's sentence after being sentenced to time served. This court then cited two cases as examples of where qualified immunity should be denied under those circumstances. One was Grant v. Gussman, the case we're here for today. Subsequent to this court's ruling, the trial court read this court's decision, looked at the evidence and the law, and denied Secretary LeBlanc qualified immunity. And the trial court got it right, because this court in Hicks was not breaking new ground. It was reaffirming a clearly established line from prior case law that defines when a jailer will and will not be granted qualified immunity. And that line comes most clearly from Porter in 2011, which reaffirmed Douthat, Wuerl, and Bryan, and held that, quote, a jailer who establishes a record-keeping system in which errors of this kind are likely, he will be held liable. That's what this court held in 2011. The next year was the Six Sigma study, of course, and from there on after that. And we know for sure that Secretary LeBlanc here knew about the pattern that affected Mr. Grant. I think we see it most clearly in a letter that he sent roughly contemporaneous with Mr. Grant's overdetention. Secretary LeBlanc wrote, quote, delayed paperwork in instances where an offender is given credit for time served or jail credit results in immediate releases of offenders. And he goes on to say, quote, we have found in these cases an offender may serve an average of 40 additional days incarcerated. So we know that Secretary LeBlanc knew about the pattern. We know that this is the pattern that affected Mr. Grant. And we know that there is abundant evidence that Secretary LeBlanc did not take steps to fix this problem or even set a goal of fixing the problem.
Counsel, can we back up for just a second? And I'm a little confused about the analytical posture of the case. So on June 30th, 2016, your client was sentenced to time served. And I'm assuming, based on everything I've seen in the record, that on the night of June 30th, your client spent the night in the sheriff's office jail.
Yes.
And then spent the next roughly 12 days there until July 12th, at which point he spent the night in a jail owned by the Department of Corrections. Am I understanding that?
Yes, correct.
On June 30th, could he have sued the Orleans Parish Sheriff's Office in habeas? Said, I would like to get out of jail.
Yes, I think he could have filed a habeas motion.
So why doesn't that end this case?
Because there's no procedural requirement to file a habeas petition. And in fact, the problem would not necessarily have been solved with a habeas petition because Mr. Grant already had a trial court judge who was on his side here.
And that's exactly what I'm confused. So let's take the two answers you just gave me.
Sure.
One is there's no procedural answer, to which I'm confused by because the entire Heck versus Humphrey doctrine, which the other side raised in the district court, and I'm confused by the district court's rulings on those two, is exactly that procedural mechanism, which says that if you can do it in habeas, you must do it in habeas. You can't wait to do it in 1983. And then the second thing is that you could have brought the habeas petition to Judge Burris, right, who, as you point out, was already on the side, was actively, oddly perhaps, in participating in the case with other lawyers, and there's all kinds of oddities about how the district court went about doing this. But the district court, if presented a habeas application, could have granted it that day and ordered the jailer to release your client.
So going back to your first question about Heck, respectfully, Your Honor, Heck does not apply here. What the Supreme Court said in Heck is that a person can't bring a civil rights claim for damages that necessarily implies the invalidity of their sentence, and that's not the case here. Mr. Grant is not challenging or implying the invalidity of his conviction or his sentence. He's asking that the DOC have followed through with it, right? And so that's the reason why the trial court here said Heck does not apply. That's why the other judges who have similarly addressed the Heck question have found it does not apply to an overdetention context, because overdetention in no way necessarily implies the invalidity of a sentence or conviction.
But it absolutely implicates habeas, right? I mean, you're being held without judgment. 2241 commands the release of that prisoner. So it wouldn't be a civil rights action, it would be a 2241 action. I'm being held without judgment.
So when Mr. Grant's lawyers found out that he was being overdetained, they went back to the trial court judge. The first words out of her mouth were, tell me he's been released, right? And then she tried to make it even easier for the DOC by vacating his sentence and resentencing him to just credit for time served. So I'm not sure a habeas would have done anything better because they already had a judge who was working with Mr. Grant's lawyers, agreeing with them, trying to get him released. So I don't see in any way that a habeas would have factually changed the facts on the ground. And since this isn't a Heck scenario at all, there's no procedural requirement for a habeas petition.
Well, it absolutely would have changed the facts in the sense that you would have had a judge ordering the release of the prisoner as opposed to what the court did here, which was to accept a guilty plea and impose a sentence. I mean, it's sort of the opposite of that, because one could have a state judge that would say, Sheriff, you're hereby compelled under state law to release this prisoner forthwith. You'd be held in contempt for not doing it. And if for whatever reason the court, either the sheriff's office and or the district court failed to do what I just suggested, you could go to federal court and you could get a federal district judge that would say exactly the same thing. And I'm not aware of any, jailer or custodian who would otherwise fail to release a prisoner if compelled to do so in habeas.
To the extent that perhaps Mr. Grant could have taken steps to expedite his own release, maybe that's an argument for comparative negligence, right? That maybe liability should be a reduction in liability, apportioned to the Department of Corrections or the Sheriff's Office. It's certainly not. There is no case law to suggest that is a bar to a 1983 claim.
So I'll leave it heck after this question, I promise. But I want to make sure I understand exactly how you think the doctrine works. Do you think it is possible that a prisoner could have a habeas claim, not bring it, and then later bring a 1983 claim for the exact same injury? That's your understanding of a heck bar?
Absolutely not, if that claim necessarily implies the invalidity of his conviction or sentence, right? And so if this were a scenario where Mr. Grant's claim necessarily implied the invalidity of his conviction or his sentence, he would not. That's what heck says. However, that is not the case here. The trial court held that, other courts have held that, and the Secretary LeBlanc has not appealed on that ground. He has not appealed that the lower court got it wrong on heck, so it's not even before this court. But I understand your question, Your Honor. And here, I think we are really looking at what are the basic obligations of a jailer. A jailer's basic obligation is to hold an inmate for the length of their sentence and then release them when that time is up. And what Secretary LeBlanc has known since 2012 is that that was not happening. And it was not happening to many, many inmates for exactly the same reasons as Mr. Grant, which was there was not any sort of time computation after sentencing. And for some people, that's not going to be a problem. If you're sentenced to 20 years in prison, if they take a couple months to get around to calculating your sentence, it doesn't make a difference. But there are a large number of people in Louisiana who are sentenced to either credit for time served or a sentence that is equal to or less than their pretrial detention. And for those—
Counsel, do you agree with your opponent's characterization of LeBlanc's liability in this case as being supervisory in nature? And I guess the sub-part of that is the exact question I asked him. Is there anything in the record you could point to show us that LeBlanc actually was personally involved in either the calculation or the approval of a calculation or any type of countermand as to a release date?
Your Honor, there is no indication that LeBlanc was personally involved. He doesn't get involved with every inmate every day. However, this court has previously held that's not the question you ask. Under cases like Hinojosa, the question you ask for the person at the top is, did they know about the pattern? And did this particular plaintiff fall within that pattern? And if that's the case, then there's liability. It doesn't matter whether LeBlanc personally looked at Rodney Grant's name or not. If he knew about a pattern prior to Rodney Grant's over-detention that Rodney Grant fell into and was deliberately indifferent with regard to that pattern of over-detention, then there is liability. So to answer your question, yes, it's supervisory liability. No, he didn't know anything specific about Mr. Grant, but he was abundantly clear on the pattern and didn't take the steps to fix it or set a goal of fixing it or work with other entities to fix it. He simply allowed it to continue.
Is part of your argument also that qualified immunity would, in this case, would be something that could be argued to the jury, and there's a pattern jury instruction that could be provided and a blank on the verdict form? Is that within the realm of how you see this case if you succeed here today?
Hypothetically, yes. So I think I find it strange to be asking juries about qualified immunity, but this court's case law is that can be a jury question in some scenarios. And so it is plausible that if this claim goes to trial, that could be put to the jury. And there will be a trial with Secretary LeBlanc no matter what, because there's the false imprisonment claim in this case, which is regarding him, and that has not been appealed here. So there's going to be a trial with Secretary LeBlanc, either way, and that could be part of it, Your Honor. And to Judge Oldham, your question about 15566, that is brought up in our brief at page 10.
It's interesting, but only as like a aside, as to say like the district court noted it. There's no argument developed at all.
Yeah, I think it is significant because Secretary LeBlanc tries to argue that what he is doing is mandated by law, right? That Article 892 says that the sheriff gives the documents to the DOC and they just have to wait. And it is true that state law says the first part, the sheriff gives the documents to the DOC. Nowhere in there, nowhere in state law, they don't cite any provision. There is no provision that says the DOC has to sit back passively with its hands tied and wait until they get the last piece of paper to compute this person's time. However, what state law does say is that if the paperwork isn't with the inmate, don't accept them. And I actually disagree with my respected colleague. I don't think there is a policy to that effect other than the state law provision. I don't think they comply with that in any sort of regular way. I think the reason—
You didn't argue any of that in your brief, so I suppose that's not really before us.
Right, exactly. But I think it goes to what is 892 and 15566 for. I think primarily it's for the inmate. The papers always have to be traveling with the inmate so that a jailer who gets this person knows why they're incarcerated and whether they should be incarcerated. And so it reaffirms the basic premise, which is a jailer, if they're going to hold someone in their prison, has to know why they're there, has to know that their sentence is not over. And in Louisiana, that has been happening over and over and over again. And I think an argument below that Secretary LeBlanc abandoned on appeal is he was also trying to argue that Mr. Grant should have just been held indefinitely. That's at the record site 5145. LeBlanc argued that they had the legal authority to hold him and hold him and hold him until the 27th. I don't think they're making that argument here. The 30B6 deposition of one of the time computation people similarly said their understanding of when an inmate's sentence is up is when they compute their time, not what the judge said. And so I think this is fundamentally about whether Secretary LeBlanc's Department of Corrections is carrying out the orders of judges or not. And they're not. And they didn't with Mr. Grant, and they didn't with thousands of other inmates between 2012 and when Mr. Grant was over-detained in 2016. And that is why this is exactly what this court suggested in Porter would merit the denial of qualified immunity, right? This court said in 2011, 5 years before Mr. Grant's over-detention, that the head of a Department of Corrections who establishes a record-keeping in which errors of this kind are likely, he will be held liable. And so Secretary LeBlanc was on notice. The law was clearly established well before Mr. Grant that this is exactly the sort of scenario in which someone in his position might be held liable. We know that what happened to Mr. Grant flowed from LeBlanc's policies. We see this at record site 3224, a 30B6 deposition. The deponent was asked, so the actions that the people in the pre-class department took with regard to Mr. Grant flowed from the DOC policies approved by Secretary LeBlanc, correct? The answer was, from what I see in the file, yes. And it is true that Secretary LeBlanc early on took some steps to mitigate over-detention. He set a goal of only over-detaining 450 people per year for an average of 31 days per person. But after those initial steps, this pattern of over-detention became baked into the system. They put it on their website that it could take up to 12 weeks to compute someone's time. That's at 2874. They put on their voicemail that it could take 90 days to calculate someone's sentence. That's at 3008. The reason why they put that is because they were getting a lot of calls from people saying, why is my loved one still in prison? Their sentence is up. And so to discourage people from making phone calls, they put this thing on their website and on their voicemail that said, it's just going to take us a long time. Secretary LeBlanc was receiving emails from judges, from lawyers, notifying him about the problem, he didn't fix it. He didn't put it in any strategic plan. He didn't take the basic steps that might fix it. And so it continued. I'll contrast that with some other things. If he set a goal of only over-detaining 450 people per year, by contrast, he set a goal in the strategic plan of obtaining 100% on-time deliveries of products from prison enterprises. And I think this all goes to the question of, is there enough material in the factual record that a finder of fact could conclude that he acted with deliberate indifference? The trial court concluded yes, and she was correct. There is such an abundance of evidence that it would be reasonable to so find. And so unless there's other questions, I'll just close with two quotes from this court's case law, which was, in Whirl, this court held that we must, quote, never forget that we are dealing with a man's liberty, and a game of who has the paper and who saw the paper is not constitutionally playable. And also, this court said in Bryan v. Jones, where there is no discretion and relatively little time pressure, the jailer will be held to a high level of reasonableness as to his own actions. Just like in Whirl, this is not a split-second decision-making. This is not an officer's choice of whether or not to fire a gun in the moment. It's a question of, have you set up a system that gets people out when their sentence is up, when a judge has ordered that they be released, or not? Here, it was not. And for that reason, qualified immunity should be denied. The trial court opinion upheld. If there's no other questions, I'll rest there. Thank you, Your Honors.
Thank you, Mr. Most. Mr. Wallace, you have 5 minutes of rebuttal time.
Thank you, Your Honors. I'll start with one point that that my colleague left off on, talking about a jailer and referring to Secretary LeBlanc as a jailer. This court actually, in its 1980 opinion, Douthat versus Jones, recognized a distinction that I think has been lost in this case. And that is, qualified immunity changes a little bit depending on who asserts it. If it is what the court called a jailer, like a sheriff or maybe even a warden, that person has very little discretion. One step above that on the spectrum is a police officer. They have a little bit more discretion, so they're given a little more leeway. And at the top of that spectrum is what they refer to as a prison administrator, just like Secretary LeBlanc. This is someone who has very broad duties, does not hold the keys to the cell by any means. He runs the state prison system. So I think considered in that light, and the distinction that was lost here is that this was not basically an issue that Secretary LeBlanc could solve by himself. My colleague said that there's record evidence that other plaintiffs were held beyond their scheduled release dates for the exact same reason in this case, and that's not true, Your Honors. There's no record evidence suggesting that inmates are pleading guilty to Louisiana felonies while on parole, which, as a matter of law, automatically revokes a parole, and then accidentally turning out to have been that they weren't, the conviction didn't violate the parole because the offense conduct predated his parole status. So there's no evidence in the record that this exact same thing has happened before, especially given the fact that the state court judge issued what amounted to an illegally short sentence in this case, which complicated everything. My colleague suggested that it's the policy of the Department of Corrections to sit back and wait. I think really that's an unfair way to frame what the policy is. The policy is to follow state law. When someone is sentenced in state court, the Department of Corrections has no representative there. There's the prosecutor, the defense attorney, the defendant, maybe a bailiff, the judge, the clerk of court. Whatever happens that day, the Department of Corrections only finds out about it if someone tells them. That's how the legislature designed the system, and there's nothing objectively unreasonable about that. And certainly it's not objectively unreasonable for the secretary to form his policies in reliance on what the legislator decided should happen to allow multiple entities who don't control each other to cooperate. I think what I'd like to finish on is just to say that it's not as if nothing is happening to address sort of what amounts to the bigger issue lurking behind this case and what did not lead to Mr. Grant's alleged injury in this case. There are legislative committees looking into this. The department has applied for funding from the Department of Justice to try to create a web portal. Some of it is and some of it is not, Your Honor. The concurrent study resolutions are not in the record because the first one was in 2019 and the second one was in 2021, the most recent legislative session. Some of it is in the record in terms of the 2019 DOJ grant application that the plaintiff says shows deliberate indifference. What it actually shows is the department applying for funding to try to set up some sort of web system where everyone can basically upload paperwork immediately so that this type of issue doesn't happen. But I'm only raising that to just address what may be practical concerns in this case. Ultimately, they are legally irrelevant because we're talking about what Secretary LeBlanc could actually do in this case. And the law doesn't require him to go above and beyond what state law requires locally elected officials to do to be entitled to qualified immunity. The question is, was his conduct reasonable under the circumstances? And in this case, it was, Your Honor. We therefore ask this court to reverse the district court and hold either that Secretary LeBlanc himself, not the state, not the department, not somebody else, did not violate Mr. Grant's constitutional rights, and second, in the alternative, that his conduct wasn't objectively unreasonable under clearly established law, defined at the appropriate level of specificity. If there are no further questions, Your Honor, thank you.
Thank you, Mr. Wallace. All right, we have your arguments. The case will be submitted, and this concludes